I always like to advise is like, no matter how like fun and artsy and like IP focused your practice is, like when you're wading into cryptocurrency, it's still super volatile. And that's like volatile in terms of the asset values. For example, this past couple of weeks, right? I have clients that sold NFT projects where they made $5 million in Ethereum, but then Ethereum goes down 50%. So now they have $2.5 million in the bank, but they also have a tax liability on the $5 million sale. So like it's as the attorney, like there's things to think about how you can advise your clients, like things you can do to be defensive and stuff like that. But then also just like the regulatory legal aspect of it is very volatile, right? There's not a lot of clarity out there. So, you know, we're getting better and figuring out as we go along. And that's one of the things reasons I like doing these kind of presentations is because we get to talk about these things, and especially with the section. So thanks for having me. Really want to just quickly talk about, I'm going to breeze through, like, hopefully you've had some NFT basics kind of knowledge. If you don't, it's going to be really hard for me to give that to you. So I'm going to skip through that a little bit. And I think when we get to why I'm doing that, I think it'll be okay. Because I think there's starting to be a lot of just IP issues that don't really matter. I mean, you need to know the NFT side of it to understand what's happening technologically and how to handle it, like for clients. But from like just understanding like the disputes that are starting to come up and some of the IP issues, I think it's less helpful if you don't already know it, to like maybe you can go in backwards, understand what's happening on the legal side, and then kind of migrate to the technology. And so I'll go through some of the categories here. I like to think about the blockchain as kind of this pyramid here, right? So the blockchain, on top of the blockchain is cryptocurrency. Cryptocurrency enables smart contracts. And then there's tokens of fungible and non-fungible varieties, right? So really quick, again, if you're not familiar with this, it's going to be too fast for you to get it on the first time, but Bitcoin is just digital cash. If you haven't read it, read the Bitcoin white paper. It allows people to send currency. That's it, right? Ethereum is enabling smart contracts. So if you haven't read the Ethereum white paper, I would suggest reading that also. The technical documents are really easy to read, and then you can kind of build up knowledge from there. And the idea is this is a decentralized platform that allows smart contracts. Smart contracts aren't legal contracts, but are automatically executable computer programs. I like the analogy of a vending machine. You put in $1, press a button, something comes out, right? So these are self-executing contracts that say, if you give me Ethereum, I'll give you an NFT, right? And then different types of tokens. So fungible tokens, equivalent to like currency, and then non-fungible tokens are unique, like real estate, for example. And we even have case law over real estate is unique, and so it's irreplaceable, that kind of thing, right? So the idea is the blockchain is creating unique assets which are not interchangeable, which then carry certain rights. And what I'm going to get into the rest of the presentation is, this is the kind of presentation I was giving at the beginning of the year that took 20 minutes to go through, right? So if you didn't get all that, I apologize. We can find some other time to chat more about the building blocks, right? But the important part is now you have these technological assets that allow you to now build like second layer rights on top of them. And so that becomes relevant to IP, because I think what you're going to see over the next few years is these intellectual property assets more frequently, or NFT assets more frequently carrying IP rights and allowing people to act as a licensee of those rights, right? So there's a company that creates an NFT, they're granting license rights to NFT holders, and then NFT holders have the ability to then take those license rights and do other things with them. And so a lot of what I'm going to talk about the rest of the presentation is about just how you can, inbound, right? So you're a company, you're building all this IP rights, and you're going to create an NFT project. What rights should you be thinking about? And what rights should you as an attorney be advising them to be thinking about in terms of protection? And then that second part, right? Delivering those outbound rights to the end user, thinking about what the license terms are, and how the end users are ultimately going to then, take NFTs and go do other IP related things with them. So just to recap, right, NFTs are a new way to track digital ownership. It's an intangible asset. It can track IP rights. It can potentially license IP rights. In fact, the NFT standard, non-fungible token standard, again, going back to like this white paper concept, if you haven't read the underlying documents, like good place to start. Read the proposal for how non-fungible token standard works, what it can enable, what the technology can do, because that ties directly into what's going to be technologically feasible from a IP licensing transactional perspective on the blockchain. And then just an analogy I like to give for trademark attorneys, which I believe there's a few in the room. There's just this registry number, right? It's just here you have a centralized registry, unique number 431. What does that tie to? Well, there's a USPTO centralized trademark registry that corresponds that number to the Apple computer logo, which of course has an insane intangible value, right? So I think as IP practitioners, we're familiar with that concept. Well, now it's, what does it mean to take, instead of a centralized database like the USPTO trademark, like the registry, and make a decentralized database, and then ascribe value to different intangible assets, and then allow people to use those in different ways and license them and things like that. So of course, in the centralized world, we have judges and courts and body of law to mediate how that all works together across international jurisdictions, and people like WIPO and INTA coordinating those things across the world. It's a little bit different in a decentralized world, right? The community of people that are doing these things have to figure out how it all works together, or they're, perhaps on a national level, things will emerge that helps us talk about these things. So where are we here, right? So you hear Web3, what does it mean, right? Web1, username, password. You probably also have, some sort of terms and conditions underneath there, click I agree. Web2, right, same thing. You're using, there's just different ways to access. Web3, I am using my decentralized self-custody cryptocurrency wallet to connect to the blockchain and then execute transactions, to digitally sign transactions, to agree to legal documents, using my wallet address as the authorized party to do those things. So we have, just thinking back to this, Web1 centralized bank, you have terms and conditions that control how Wells Fargo, the banking relationship that goes along with that. And, if you lose your money or it gets hacked, they can probably do something about it. Coinbase operates pretty similarly to that, although I don't think their support's very good. But you agree to other terms and conditions. This is different, right? This is Uniswap. How do you interact with this? This is like the vending machine. You connect your wallet. You say, I want to give you Ethereum. You'll give me back wrapped Bitcoin, which is a Ethereum-based Bitcoin. Okay, so it's taking that Web3 example here, right? So then you get into NFTs, right? Same thing. They're centralized or relatively centralized marketplaces like Nifty Gateway, where you're agreeing to terms and conditions by logging in and creating a username and password. And then there's things that are kind of semi-centralized or fully centralized, depending on the different examples. Here it's like OpenSea, right? And you're connecting your wallet and using that to interact with the website and to buy, sell, trade NFTs. So I just covered a lot in 15 minutes. If you're not with me, I'm sorry, but I really want to get to the second half of this presentation, which is about just generally IP rights that are attached to NFTs. And I think the reason I'm moving so fast is because I think at the beginning of the year of 2021, it was really like, what are NFTs and how does IP this is this new kind of interesting thing. I think over the course of last year, at least in my practice, there was a huge shift from this is this interesting new thing to we are now creating real businesses that are centered around this technology. And as I mentioned earlier, right, they're selling, $5 or $10 million NFT sales. They're on, $20, $50 million annual run rates. Like, these are real businesses. They have real IP needs. They're dealing with creating, characters and books and television shows and using their NFTs to create an initial idea that then will act as like this foundational product, which will then be like a licensed product that can go into the traditional ecosystem and have someone produce a television show, right? For example. So it doesn't work if the company isn't a real company and doesn't really own its IP. So, that's, I think, one of the big thoughts here, right? Is thinking of these companies as real entertainment businesses, as them now seeking real intellectual property counsel about how to grow and protect their intellectual property, how to exploit it, how to work on commercial licenses and other agreements to just do interesting things with their NFTs are fundamentally where they're starting from. Or the reverse, right, is traditional companies saying, hey, we're doing all these other things. How can we now, move into the metaverse, use NFTs as a new category for, we're doing physical goods like Nike's doing shoes. Well, now we want to do virtual shoes, right? So what sort of IP rights control, converting the traditional assets into the metaverse? So just to kind of go through the different categories here, we have trademark protections for NFTs. There's, obviously a huge trend now. I'm sure many people in this room have seen this, of people seeking to file for, either traditional goods and services now sold as NFTs or some other blockchain related service, or just like fundamentally they're just the new company that's what they're doing. And then also a lot of brands that are saying, hey, we don't know what we're doing in the metaverse. We don't know what we're doing in crypto, blockchain, NFT world, but we might do something, and maybe we should file intent to use. Maybe we should do, or just enforce our marks, so that someone that's coming in and doing things isn't going to conflict and prevent us from using our IP in this category. So that's something to be mindful of there. And then, a big category, which I think is fun, is this anti-counterfeiting, big brands thinking about how can we use blockchain as an additional layer of anti-counterfeiting, so LVMH, De Beers, thinking about luxury goods and how you just create an additional authentication layer that ties back to, this is provably a unique asset, it's provably authentic, and you can tell because of some technological tag that ties it to a blockchain record. And it's a good question, right? Like, well, why can't we just use a centralized database? Why does it have to be a decentralized blockchain? Some of that makes sense. Some of it, I think, is still being figured out, to be candid. But I think one thing to think about is just like supply chain and just like getting everyone synced up at all the same time, and letting consumers and people within the supply chain all have access to the same data at the same time. It seems like there's probably some use case there for blockchain. So same thing, patent protections for NFTs this is Nike's Crypto Kicks. Also really heavily expanding. I know I've talked with some people in this room, like Joe Englander, about how this is starting to tick up. And you see here, this is from, I think, November 2021, but just hockey stick like growth, I think, for everything we're talking about in this industry. And then, I think the real fun category is getting into, copyright, thinking about the traditional bundle of rights. There's obviously nothing in the US code about NFTs, but there's probably not a lot in existing IP license agreements and contracts about NFTs. So there's a lot of ambiguity as to exactly how this is going to apply. There haven't been any reported decisions as to the application of NFT related copyright issues, but we'll run through some of the disputes that I've seen so far. So this is just like getting back to that idea of, if I'm representing the company, what am I thinking about in terms of making sure that company that's coming into the IP that's coming into the company is protected, right? So it's protecting at the company level. A lot of these NFT projects they start off as their friends in a Discord server. They're not thinking of themselves as a formal business, and then they evolve into that. But they're all very often, they're distributed businesses. They're working with people all around the world who are acting as independent contractors, artists doing works for hire. They might be employees. It's formalizing all this. It's making sure that they have proper agreements in place that the company is going to own all the IP or has license to use all the IP that's being generated. Being thoughtful about the sorts of trademark, copyright, patent protections that the companies are seeking in order to formalize some of those IP grants that they're getting. And then it's on the outbound side too, right? So it's formalizing, you're partnering with other people, other commercial license agreements, things like that. And then a big category is just, as I'm selling NFTs to end users, thinking about, what are the terms of service that will apply in this decentralized world? Is it some sort of click wrap? Oftentimes there's not even, you're not checking a box in the way we would think about with like a Web 1 or Web 2 kind of world in a traditional world. So it's making sure that you're engineering some enforceability for, what is ultimately, a consensual agreement between two parties as to what the terms of service that will apply. Or is there just some default, right? I'm reserving all rights. There's no use of IP allowed to end users. How are you making that clear? And then if those rights are exceeded, how are you enforcing them? So, I think it boils down to, this is one kind of fundamental question, right? Do I have the right to use whatever it is, some intellectual property asset, into an NFT? I want to create an NFT. Do I have that right? Well, I think there's a range. It can be really complicated, right? Or it can be really simple. If I take a photo and I own that photo, I can probably, I own the copyright by default. I can probably manipulate it and do fun things with it or make NFTs with it. But once you start getting a little bit down this bulleted list, it gets a little bit more complicated, right? Because oftentimes you're having different, partners. There's people that are using licensed content. They're negotiating, complex license agreements with multiple parties that are enabling you to do NFT uses with this licensed content. And then one of the IP rights I didn't talk about was, this privacy, name and likeness one, but that's one that's come up a lot about, celebrity entertainment uses. So I like this example of the Disaster Girl meme. This girl wanted, she was a 4-year-old girl at the time, standing in front of this burning house. Her dad took the photo. So I imagine it was a pretty easy conversation for her to go, hey dad, I want to sell an NFT. Do you mind if we do that? Like the copyright seems pretty clear there. And she sold it for like, $500,000. So, pay for college by selling her meme as an NFT. So kind of fun, right? Starts getting more complicated when you're someone like Quentin Tarantino, right? You want to sell NFTs of the original manuscript of the Pulp Fiction script, right? Well, what happened? You didn't license the manuscript to Miramax, but Tarantino licensed essentially the final draft, right? He said, this is the script that I'm licensing to Miramax. I reserve certain rights that, via a contract that are, Tarantino's rights. I grant Miramax some other rights. Arguably ambiguous as to who has the right to make an NFT of the original manuscript of that script, right? So Tarantino thinks he has the right to do it. He went off and said, here's my NFT project. This is what I'm doing. Miramax obviously took issue with that and sued him, right? So fundamentally, this is really like a license dispute. Like I created some intellectual property asset. I granted you rights to use it for certain purposes. I reserved some other rights. Who has the right to do this NFT use that was not contemplated back in the 90s when the manuscript was originally created and was not contracted for? So I think this will be an interesting case. I think it's interesting because presumably Miramax has other people that were recipients of similar screenplay contracts and has a vested interest in an outcome beneficial to them for this case. Whereas, I think Tarantino stands to probably make some money if he can, sell this off as an NFT. And so maybe there's, who knows if there's any reported decision that's going to happen here or if it's something that will resolve amicably. But I think it's a fun example of, trying to administer how old license agreements are now going to work in this new use case. And you see some of the argument there in the complaint. Here's another recent case that just happened a couple weeks ago. Is there was an artist who created a Meta Birkins project, right? It's a collection of 100 unique NFTs that were based off of the famous Birkin bag by Hermès. And the artist sold an NFT package of these different furry, faux fur, because they're environmentally conscious, of course, NFTs. And once this kind of picked up some steam and there was some pushback by Hermès, he added a disclaimer to the site, of course, that they are not affiliated, associated with, authorized with Hermès, right? But Hermès did not think that was sufficient, obviously, and filed a complaint alleging 7 counts, including trademark infringement, false designation of origin, dilution, cyber squatting for the metabirkins.com domain name, New York common law claims, and a dilution claim, right? Because they believe that the Birkin mark is famous, and so they're also asserting dilution. And I thought, Hermès' perspective here is interesting, right? It's because although Hermès is not yet, minted and sold Hermès NFTs, consumers might expect that they would do that, right? They're a famous brand. We expect that a famous brand would enter the NFT space. They see other NFT Birkins in the space. Like, is that confusion? Is it dilution? I think it's an interesting perspective of like a big brand. We're not doing anything yet, but we want to protect our ability to do that. We don't want to like give away that optionality, right? And you see that here in the second paragraph in the complaint, second paragraph on my slide, but in the complaint they said, right, it may ultimately preempt our ability to offer products and service in virtual marketplaces that are uniquely associated with Hermès and meet our quality standards, right? So just traditional IP enforcement kind of language here, right? This is the mindset of like, we need to police our mark, we need to preserve our ability to ultimately enter the space. And you see that kind of coming out here. And here's the artist's response. Mason Rothschild said, I'm not creating or selling fake Birkin bags. I've made it very clear that these are not Birkin bags. These are my own artistic statement. And he even said, my lawyers advised me that the First Amendment, which isn't, I don't know if that's one of his IP rights, but gives me the right to make and sell art that depicts Birkin bags, just as it gave Andy Warhol the right to make and sell art depicting Campbell's soup cans. So obviously there's different kind of factors here with the NFTs and so forth, but it'll be interesting to see how this one plays out. But I think, again, this is also one where it's like, we are a brand, we have certain responsibilities to protect and enforce our IP. Someone's doing something we don't like, we're gonna kind of come in there and stop this use that we don't think is consistent with our trademark rights. And so, kind of getting back to copyright, a lot of what is happening here, I think, is going to circle around, what is a fair use, what is not a fair use. There, again, haven't been any reported decisions as to, applying the fair use factors to an NFT use case. I think we're going to start to see some over the next, 6 months to a year, maybe. But, it's difficult, right? Because you have clients that come to you and say, hey, I want to do this. I want to make some derivative work of, something out there, but I'm doing it in an artistic way. It's going to be very transformative. It's making NFT, like how transformative is just making an NFT version of something, right? It is making a Birkin bag, an NFT Meta Birkin bag transformative, or is it something that, is more of like a slavish copy, or is, really just kind of displacing the market for that authentic good, right? So it'll be interesting to see how the fair use factors are applied here. But it's difficult, right, prospectively to say, well, here's exactly how they're going to apply, because one, fair use is notoriously difficult to apply even in like established fact patterns. So how are we going to like guess how it's going to be applied in the NFT context? So I think it's really fascinating. And I think it's, no matter your stance on NFTs and where they fit into all this, I think the IP case law that's going to emerge from here is going to be pretty fascinating. And there was a case just this past year, last Supreme Court, about fair use and about the technological issues there. which Justice Breyer, I guess just in the news, had a nice, I like this quote here, right? Fair use plays an important role in determining the lawful scope of computer program copyright. It can help distinguish amongst technologies. It can distinguish between expressive uses and functional features of computer code where those features are mixed. So he's not talking about NFTs, but I think this kind of thought is NFT-ish, right? You have these NFTs that are acting as both this technological thing, but also as this vehicle to carry expressive art and to allow people to create new art and then fix it, in a tangible medium on the blockchain. And it may create different incentives, right? You're talking about copyright incentives and, just other fair use factors, right? And it's like, well, those may be a little different in the NFT context. How are you going to account for that? And then, so like, this is another NFT project that also got a cease and desist letter. It's actually I don't know if anyone here knows more about it than I do. There was a Florida firm involved, so perhaps, but this is probably the weirdest NFT project I've seen in the past year. And I don't say that lightly, like that's like a pretty high threshold for me. It's like, there's a lot of weird stuff happening out there. This one was like especially weird. This is called Non-fungible Olive Gardens. I think you can start to see, who might be upset about this. And the NFT project said, here's an opportunity to be an OG on the blockchain, to bootstrap a community of Olive Garden enthusiasts, to mint an NFT that is tethered to an Olive Garden franchise. So reasonable cost of a tour of Italy entree, $19.99 paid in Ethereum. And you see that red button, you could click to mint a Olive Garden franchise. You could also still today mint a breadstick if that's something you want to do. That's for free, you just gotta pay gas. And so here's what the NFT looked like, right? It's NFT. Each NFT corresponds to an Olive Garden store number. In this case, the one in Orlando I picked for our presentation. Here's the Orlando location. It's an NFT. It has certain properties like store number, online ordering available, carside pickup available, background fettuccine Alfredo. And here's the FAQs of what the project stands for, right? It's very clear, right? This is not garden restaurants. This is not an Olive Garden. You don't own Olive Gardens by doing this. You're just a fan of the franchise, and you're granting no rights or privileges in meat space Olive Gardens. Although this may change in the future, according to the roadmap, we're not affiliated. You're just buying, representative artwork of Olive Garden franchises. Actually, copyright did not come up into this case, at least yet. I think it's interesting because there's obviously copyrighted photos here. I don't know who would own that copyright and would be able to assert it. Maybe that's why it wasn't asserted. But Darden Corporation issued a takedown request to OpenSea, right? So one of the issues here is the NFTs exist on the blockchain. They don't exist on OpenSea. OpenSea is just a front-end marketplace that's layered on top of the blockchain. OpenSea is where a huge amount of transaction volume is happening. So kind of akin to like Amazon or eBay, right? It's like you can still sell counterfeited goods in other markets, but if you take down those kind of high revenue, high visibility markets, like you're effectively taking down a lot of the ability for people to transact just on a regular basis. So OpenSea does have a takedown process, DMCA and trademark submissions. You can submit there. They're pretty relatively quick to respond. And they follow like the DMCA procedures, just as you would in Amazon or eBay, right? And it doesn't work 100% all the time immediately, but if you push them, there's usually results. So Darden did a takedown request. OpenSea took it down in the takedown request, which was published by the Non-fungible Olive Garden project. Darden argued that we have registered trademark rights. The project violates our rights, and it gives the false impression that Darden has sanctioned this use or that the project is affiliated with Darden. I think this case is a little bit different, right? I mean, like we can go here to the project's response, right? Like we've made it pretty clear that we're not officially associated with Olive Garden. or just a community of fans or a fan-based project. Where I think it's hard, right? Because they are admittedly using the Olive Garden name, I guess not the logo, but you know, and we have this FAQ that says we're just fans. We never misrepresented ourselves to our community or the press. They're very clear, like we're just fans. We're not associated with the project. We're just this weird NFT thing. So like where is it an art project? Where is it a where does the art project and transformative use of, you know, this trademark claim, but you know, think about copyright as well. Where does the artistic journey end and the enforcement begin? You know, how are the rights intermediate here on the blockchain and these new uses that, you know, the established brands aren't going to like, but I think these communities are becoming, you know, maybe more clever about how they're doing these things and how they're referencing existing materials and trying to create something around that. I just think this is like, it's fundamentally like a different type of litigation than like the Quentin Tarantino one, right? It's like, it's weird. That's kind of how I feel about it. So that's like, can I make an NFT project that does X? And the next, you know, part of the presentation is, all right, I have an NFT. The NFT itself isn't infringing, but can I use my non-infringing NFT to then do some other use case, right? So here, again, there's a spectrum of different NFTs. Here's one of my favorite collections is Fidenza. It's this, it's part of the Art Blocks project, which you may have heard of. And this is an art, you know, it's art, it's generative art. It's the Tyler Hobbs is the artist. He creates a smart contract depending on, you know, at the point of mint, like the purchaser of the NFT, like at the time they mint, generates a random seed. The smart contract creates a different looking NFT depending on, you know, when it was minted, and then it looks different. There's 999 of these. Each of them are like completely unique, but also recognizably part of this art collection because they have the same underlying code that makes it run. Tyler Hobbs said, I want a Creative Commons BY-NC 4.0 license to apply to this work. You know, on the right side of the screen here, you see that's the Creative Commons license. So, you know, you can share, redistribute the material, any form or medium. You can adapt, remix, transform the material, so long as you give attribution and do it for non-commercial uses, right? So it's just straightforward. You know, this is art. A lot of art is sold without commercial licenses, without Creative Commons licenses, really more of like just like any normal art, right? You don't have all rights are reserved to the artist. You just have a right to, you know, display and, you know, for personal use kind of uses. But, you know, these NFTs, like for example, the one I have from the screen, this last sold for $3.3 million. So people are buying these, you know, yeah, for a personal art collection, but then also like, what if I want to display it in a gallery? What if I want to do, you know, make other uses of it, right? So that's what, like, something to think about, right? And I think that's ultimately, like in this example, right, it's going to be up to the artist, or, you know, in other cases, up to the NFT project of like, what are the uses you want to grant end users and why? And there's different market reasons why you might want to go one way or another. And there's obviously artistic reasons why the artist may want to reserve certain rights or provide certain, like, you know, commercial rights only on a non-exclusive basis to reserve commercial rights for the artist or for the project, that kind of thing. There's also a growing trend in the NFT space. Here, there's a project called Cryptodes, which are these little small amphibious creatures. And they were issued via a CC0, Creative Commons, like public domain license. And this is becoming more popular because there's this idea, well, the NFT itself establishes like ownership. The NFT holder is the person that holds that unique asset. You can't really get in the way of that, right? That's mathematically always going to be verifiably true. Why do the IP rights even matter? Why don't we just make everything public domain? Everyone can do whatever they want with this stuff, you know, make all sorts of different uses. On the bottom half of the slide, you see other derivative projects, right? So there's an official Cryptodes NFT collection that's associated with the like mathematically unique Cryptodes smart contract. Any particular NFT is always going to be mathematically part of that smart contract. Any other NFT is not a real authentic crypto. right? So you think about authenticity and IP rights and all those things. It's like, well, I know what the authentic one is because there's only one of them, and I can always mathematically prove that. Who cares what happens to the IP rights? I mean, it's not exactly what they're saying, but that's kind of the mindset, right? Why don't I just gift the IP rights to the world? And if the more people build on top of that, the more value is going to derive back to the original creation, which is still, always owned by the individual holder, right? And they start thinking about, well, if the individual holder can find a way to, get royalties for that, or something, there's interesting things that can be kind of built on top of that. One of the words you hear a lot of is composability, right? In the blockchain world, there's an asset, it's composable. That means like, this is the default starting block, and things can be built on top of it. And then granting public domain usage allows people to do whatever they want with it. And that value ultimately will derive back to the original holder or to the original artist or creator. So that's an interesting concept too. And that's also very, very different, I think, than it's a very copyleft kind of notion. But I think it's something to understand that's what's happening. And there is a market demand for that kind of mindset. So, and here we have, CryptoPunks. This is one of 9 alien punks, which I think sold for like, $7 million, something like that. Larva Labs, the creator of CryptoPunks, said, here's the NFT license. You can use it for personal use up to $100,000 in commercial activity. But then, some of the CryptoPunks holders are becoming very famous in the digital world. And they're like, well, I want to make a TV show with my CryptoPunk. Well, now I got to go to Larva Labs, and Larva Labs is telling me no, or they want some exorbitant fee to do it. I don't want to do that. So there's some pushback there. And there's been a lot, like within the CryptoPunk community, people are kind of riled up. Like, I have an NFT. I want to be able to do what I want with it. But Larva Labs is like, well, we're making a TV show and we have other aspirations, and that, that's accruing to the company. So it's interesting from a licensing perspective, right? Because I was talking about clickwrap and how do we make sure that the licenses are binding on the end users, things of that nature, right? So when CryptoPunks were first given away in 2017, again, $10 million asset was freely claimed back in 2017, if you're in the right place at the right time. They had no license. Just like, here, claim this NFT. No one was thinking about licenses in 2017 for NFTs. In 2019, they had this draft where like every NFT holder gets a full commercial usage license to whatever they want. It was never adopted. It was only a draft. In May 2019, then they have what's ultimately the $100,000 commercial usage cap with an otherwise non-exclusive personal use license, including no right to make any derivatives. So that's the license that's in place now. But you start thinking, well, I claimed my NFT back in 2017 when there was no license in place. I never affirmatively agreed to this new license. Why should that be binding on me? I think it's an interesting argument. It'll be interesting to see if this ever surfaces. But I think it's something that every NFT project should be thinking about. Is like, what is the agreement that I want in place from the beginning? Ideally, that's in place before launch. How do I make sure that that's binding on the end purchaser? Is it through some sort of clickwrap? Is it in the metadata of the smart contract, or otherwise in the description? Like, what are the ways that I can maximize the chances that whatever the binding nature of the NFT is going to be able to be binding on the end users and ultimately enforceable if a user does something that I don't like. The other big example in the space, which I want to go into a few examples, is this, the Bored Ape Yacht Club. It's another very prominent NFT project, which very explicitly gives commercial usage rights, unlimited worldwide license to do whatever the hell you want. And if you talk to the project founders and say, hey, I want to do this, they're like, yeah, sure, go do it, right? There's this very informal, there's a license that says commercial use, but then there's also this informal structure where you can kind of within the yacht club, talk to the founders and say, hey, I want to do this usage, and they're allowing you to do that. I think that will also evolve, right, into this informal mechanism for enforcement. I don't think we're there yet, but I think the enforcement's coming next. So what are people doing with their commercial usage rights, right? So they're making beer, coffee. Like, so I want to start a coffee brand. I own a Bored Ape NFT. I can use my ape as the spokesperson for my coffee brand. and I can make $100 million selling coffee, and I keep all that revenue. I'm not paying royalties to anyone, right? That's the idea. And then there was Universal Music Group, who launched, I don't know what it's going to mean. We might find out Super Bowl, a virtual supergroup of NFTs. Like, so this is the band on the left you see here. Another project using this idea is Jenkins the Valet. I own a Bored Ape. I non-exclusively license my Bored Ape to a book project that's going to write a book that, depending on the NFT you own, will be featured as a character in the book. The book is going to go out and perhaps make money, or be turned into a movie, or generate other money in the real world. Those royalties are going to flow back to the licensors of the NFTs. So, I think this is kind of, you're starting to see a glimpse of the future here as to how are we allowing people to do licensed IP on the blockchain. People like they're just like dumb art NFT projects, and like in many cases that's true. But I think when you start looking under the hood at what people are building and the technological and legal combinations that are happening, I think they're creating like fundamentally new business structures that haven't existed before. And all of this is intellectual property. So for me, and I imagine for a lot of people in this room, like I think this is a really exciting opportunity to like define what the future of like licensed, what licensing looks like in this new universe. But of course, this is all like optimistic, right? There's lots of potential risks and downsides and things like that. So that's kind of the fun part, is thinking through what those things are. We probably can't predict where it's all going, but this is what's happening now. And the more we understand of what's happening in the moment, I think we'll better be able to understand what's kind of coming down the pipeline. So it's this question, right? So what kind of ownership rights can be transferred or licensed or assigned on the blockchain? And I think we're starting to see more and more of that. Here's just another example of it's what claims to be the first royalty-bearing music NFT, right? So you start thinking about what are these risks? A lot of people are selling. You can do a Reg CF offering of like music royalties, right? There's like a royalty exchange, like those kind of services. This is different, right? This is just, you go out onto OpenSea and you buy an NFT and you get royalties. So what are the legal risks that come along with that? It may not be an IP risk. It may be a securities regulatory type risk, right? I'll get into some more of those later. But just in terms of thinking through like, the types of, very, very high level, a lot of these projects have collaboration agreements. There's multiple parties coming together, figuring out, what are the parties' responsibilities? Where is the NFT going to be released? How is the IP going to be, coming into the project? Who's contributing which IP? Do we have licensed content? And then ultimately, how are other people going to be able to use the IP that we generate? How are we, payments is a big thing, right? We're talking about royalties. We're talking about payments taking place potentially on chain or off chain, right? Thinking about accounting. The accounting is like, oh, well, everything's happening on the blockchain. It's probably really easy to account for. I don't know if anyone's tried to do cryptocurrency taxes before. I have. It's terrible. It's really complicated. Just because it's on the blockchain doesn't mean that it's simple. And then like, dispute resolution, risk mitigation, predicting things that we haven't really thought about or haven't happened yet. And then, the other thing, right, is this enforcement idea. There's probably some optimistic type things of like using the blockchain to, fight anti-counterfeiting type activities, proving authenticity, but then also, what obligations do brands have to police, prevent unauthorized use, to go out there and do notice and takedowns, and then just recognizing, right, there's limitations to that. Just like there were limitations in, the Napster kind of BitTorrent era, right? It's decentralized. If you shut down one node, you can't shut down the entire network. It's international. It's pseudonymous. You may not know where these people are, how to reach them. And it's immutable, right? You can put something on the blockchain. There's still a lot of centralization in the blockchain world and NFTs, but a lot of it is decentralized. And so if you literally, even if you get a federal judge to order something taken down, there may not be a mechanism to remove it from the blockchain, because the blockchain is designed to be like an immutable record of what happened before, transaction by transaction. So it's recognizing limitations and what you as an attorney may or may not be able to do, and counseling a client as to the best approach to that situation, in context of whatever the technological aspects of that are. So then just like, risks, I mentioned a little bit, securities, KYC, anti-money laundering, bank secrecy, like there's lots of 3-letter words that are going on in the space. It's very complicated. Make sure you're working with other attorneys that are conversant with those issues, because they do pop up and they may not be obvious. And then just, what's coming down the pipeline, right? I think adoption of cryptocurrency over the long run, is only going to continue. And the maturity of the types of, IP things that people are doing is going to continue. There's going to be technological breakthroughs. There's going to be people building upon kind of these initial things that we've seen. I think both on the optimistic and probably on the risks side as well, right? There's going to be just more complicated things that are going to be harder to stop. Kind of just think through what those risks are and how to counsel clients as you're thinking about them. So that's it. I know that was really quick. Probably, I hope some of you are still with me. If there's any questions, or I'll turn to leadership if there's time for that, or anything else.
Does anyone have any questions? Thank you, Moish. That was excellent. Oh, go ahead, Jim.
Hi, Moish. I wanted to ask you, you had a nice chart there that showed all of the patents that have been issued with regard to blockchain.
Yep.
Have any of them gone through the courts? Have any of them gotten the what's called an Alice analysis to see if it's actually patentable subject matter? I always wonder if it's the same thing as I did this through blockchain is the way I'm doing this through Bluetooth or through the internet.
I for sure there's a lot of that. You're the patent attorney. You tell me. I think.
Okay. Well, I haven't. You had the chart.
I don't. Patents is like I don't do any of that stuff. So I think the chart was really just keywords like blockchains appearing in the claims.
Okay.
I don't know. I suspect the case law on just because there have been patents. I forget what the timeline was there. I think it was for the numbers are really insane. It was 17. There's 3 in 2016. Right. There's 17 in 2017, and as of November 2021, there was 1,300 in 2021. So figure, 1,500, probably be 3,000 next year. There's going to be more filings in 2022 than there probably have been up to now, right? So I imagine the case law is probably more developed just because there's been 4 to 5 years of patent filings for blockchain, and I know like IBM, for example, is like very active, like they're one of the top filers. So I imagine that there's some of those that have been more heavily contested, and perhaps there's office actions and things like that that are out there that more fully flesh them out.
Cool. Thank you.
Yeah, Michael, the Dune one, I didn't make it into the presentation, but the other thing I didn't talk about is DAOs, right? If you don't know what DAOs are, that's an entire separate presentation, but it's, and so you think of like a typical LLC is manager managed. A DAO is a distributed membership managed entity. So you think of you have 100 members in the company, every person has an equal 100 vote to decide what the company does, and the governance rights are voted on like blockchain, right? So do we want to buy this NFT? Yes, no. There's a quorum. It self-executes and buys the NFT. So one of these DAOs bought a $3 million copy of book Dune, and they're like, all right, we're going to do something with this thing. And it's like, oh wait, no, you don't have any of the IP rights. It's just you just own a copy of the book. So it's, now what? They did say, Michael, that they're going to try and get the rights from the estate or something like that.
Yeah, I thought that was pretty interesting and timely in light of your presentation I just saw yesterday.
Any other questions for Moish?
Was it effective? Are people like, I don't know how many people know what an NFT is. Like, what did I skip too much? Did I, this is the first time I've given the 101 presentation a lot. This is the first time I've given the 201 presentation. So hopefully people didn't lose me entirely.
I think it was great. If people want a 101 presentation, we're going to have one of those at our blockchain task force meeting at 1:30. So, but I thought this was excellent. Thank you.
Feel free anytime, anyone has any questions, wants to reach out. I'm happy to be a resource for anyone in this group. Reach out anytime. I'll talk to you. Thanks for having me.
Thank you, Mons. Appreciate it. I want to go back real quick. Everyone, can you hear me? Okay, all right. To what Woody's questions about what happened with the amicus brief. So if you recall back in our September 4th, way back when we were at the Labor Day retreat, we voted on whether to file a notice of intent to file an amicus brief, which we then had to take on triple motion to the BLS Executive Council, and they approved that. At the time, the court had not yet accepted jurisdiction of the case, nor had they agreed that any amicus briefs would be accepted. When we learned that the amicus brief, that we could file an amicus brief, that was early December, and the deadline was going to be right before Christmas. So the parties in the case moved for an extension, which therefore moved our deadline to file the amicus brief. We had a special meeting, and I dropped those minutes in the chat. We met on December 14th and discussed, now that we know that their amicus briefs would be accepted, and we had the option to file one. We didn't have to, but we filed the notice of intent so that we had the option to file the amicus brief. Now was the time to determine what the content of the brief would be. And at that meeting, which was publicized and sent out, we decided that we would submit an amicus brief focused on the substantiality prong and that patent matter should be federal court determination. And that is essentially what the brief says that I dropped in there. So we were not taking any specific side. We were really discussing this is how these matters, this is the real issue here that the patent is being interpreted and all the reasons as to why that determination should be done in federal court. So the brief was drafted in accordance with what the committee previously voted on. That's a little bit more clear. And I want to, and of course, Woody abstained both times. Since your firm is involved, but just want to make that clear. That's in the record too. But thank you for that question. I hope does anyone have any questions on that? On what the brief is or why you wrote it? Okay. I want to go back and accept those minutes, and if I can I share? Oh, you know what? I don't want 2 minutes.